Hi, Sam.
Hi, Carrie.
So you want to try this again? Do you think second time's a charm?
Well, they say 3, but let's hope for 2.
Okay. Let's get to this. Now, the court audio is currently off, just so you guys know. We saw Sarah with her little smirky face. It's like she was like sticking her little head out to say hey to the media.
Oh, I missed it. I didn't see her.
You didn't see her lean forward, her little.
It's okay. I've seen enough of Sarah.
Look at that guard.
That bailiff, yeah.
Oh, bailiff. That's what they call him.
Mm-hmm.
But I know she's so over Sarah.
I think they all are.
Can you imagine those ones that have to work with her at the prison?
Well, I feel the worst for the ones that are gonna have to. You change into your civilian clothes like in a holding cell outside the courtroom, but the bailiffs have to do that, and they have to keep you locked up in some form at the same time, which I never really thought about that until I read it somewhere.
They have the worst job if you think about it, because don't they have to like do things like pat the prisoners down and all that, and like search in crevices for things?
Yeah.
Ugh. I would say that they probably know the prisoners better than anybody else.
Yeah. Yeah. Well, they're inmates usually while they're in this process. They're not prisoners till they get to actual prison.
Oh, okay. Thank you. So Sam's been so good about reminding me that it's jail, not prison.
Right.
Because I am really bad about that. I always viewed it as the same thing, but apparently it's not.
It is not the same thing. Exactly.
All right. Let's
pray. Okay. I didn't know the difference either for a very long time.
We haven't watched this, so we were going to do a live reaction with y'all. We pray that his meeting is not so. It sounds better. The audio is anyway.
William J. for the state.
Why are they cutting him off?
Mr. Owens, you are muted, sir.
Did you just say GD?
Judge, can you hear me? Loud and clear, sir. Can I get your appearance for the record? Yes, I'm James Owens, and I'm here representing Sarah Boone. I believe I'm the only counsel that's going to be here today representing Sarah Boone. All right, very good. Ms. Boone is in the jury box. Ma'am, if you could please raise your right hand. Madam Clerk's going to go ahead and swear you in. Ma'am, good afternoon. Can you state your full name and date of birth for the record for me? All right, we are here on trial case management. In this case, I know there's been some activity over the last couple of days in the court file. And of course,
I need to say something really quick, Sam.
Yes.
It is. We have no effect over this audio, you guys. It is what it is. This is all we all have right now. So we'll play. We might be able to play some more of that Zoom on there. I don't know. We'll see at the end if we add the Zoom, but there's not a whole lot we can do about this. We gotta live with it.
Yeah, please turn your volume down if you're wearing headphones, because I'm wearing headphones. It's not pleasant. It's not on us, guys. This is the feed coming from the courtroom. So sorry.
And there's Mr. J by himself.
Correspondence between Mr. Owens' office, my office, and the state attorney's office in attempting to coordinate some hearings. The first item on the court's list is whether or not the examination of the defendant took place as ordered in the court's September 20th order.
No, Your Honor, there's no time.
Okay, when do we believe we're going to have the opportunity to have that examination by the expert of the state's choosing?
Wednesday, October 2nd at noon.
Okay, and has that been cleared with everyone's calendars? Mr. James, Mr. Owens, is that accurate, sir?
Thank you, Mr. Judge. I can't see my client. I don't know if that is an issue or not.
There you go, sir. He's on the far right-hand side of the box.
I see you, Judge.
Okay, very good. All right, so that examination is taking place on October 2nd at 12 noon. The next item that I have on my list is depositions of the recently appointed experts for the defense. I know Dr. Harper's deposition is set to take place on October 1. With regard to Drs. Brennan and Birkeland, are those depositions in the process of being scheduled. What's the status on those?
I was told by the defense that they're not calling Dr. Birkeland. He was only going to be a consultant. So there will not be a deposition of that doctor. The other doctor, we have made attempts to try and coordinate, not gotten anywhere with that. I am not even sure what he is going to do.
Judge? Hang on, let Mr. J finish his point, sir.
I'm not sure if he's going to be testifying to battered.
Judge? Mr. Owens, we can hear you loud and clear, sir. Judge? Yes, sir, we can hear you.
Oh, man.
Look at Jay. He's so mad.
I can hear you.
Is he turning red?
I think, yeah, he's not happy.
Judge? Sir, I can hear you loud and clear, sir.
Bad thing is,
Yes, sir, we can hear you.
did he just say I'm unmuted?
I can hear you.
He can't see them.
Judge Crane?
Oh, good Lord. What was that?
Jesus.
Judge Crane? I can hear you. I can't hear you.
You know I'm doing a skit out of this one.
Just don't blast people's eardrums.
I won't. I'll fix it.
Make
If I
sure.
can.
Judge Crane? I can hear you.
Margaret!
Hear you. Do not know why you cannot hear me, sir.
I'm not messing with the sound either, y'all. I think the guy on the camera is. Somebody is.
That's turned down? Or is that me? Have I turned my own computer
No.
down?
Hang on. Let me put it. On their side, I think whoever's doing this, their tech or whatever, they're messing with the sound right now as this gets started, trying to get it leveled out.
Oh, okay. I've turned what I can hear down.
Okay.
Judge Crane? I can hear you. Judge Crane?
Oh my God.
I can hear you clear.
Look at Jay over there in the corner.
Judge Crane?
Jesus. Oh my God.
Oh, I need a good editor for this one.
So this must have been why trial TV was taking a minute. They might have been cutting this out because this wasn't in the other part, was it, that we saw?
Oh, you know what I think it was? It was that zzz that we kept hearing on his side. The zit, zit.
Oh, okay.
Judge Crane?
This really does need background music.
I know, I'm trying to think of songs with silence in them.
Somebody from Orlando is calling. Hey, this is James Owens.
Oh my God. What is even happening?
This is James Owens.
That was his cell phone.
You're kidding.
No, stop. He did not answer the phone while he was on stream. He has no idea that they're waiting on him. Or are they calling him? Is someone from
They're
the court?
calling him. That's what he said.
Okay.
They're calling him. He said someone from Orlando is calling.
Oh, okay. I was like, no, he did not take another call. Margaret, get this fixed. I don't know, Margaret, but you got to get it fixed because we got to get this going.
Right?
We're already a day late behind. We've only got 19 days, Margaret. Now it's what? Oh, we're going to start hearing, Judge, we're doing the best we can. We only got 16 days.
Judge, as you know, the audio in the courtroom was not working. So you know, I need more time.
And let me guess, his house probably got hit, right, direct hit by that Hurricane Helena. That'll slow some things down.
Well, he's got a suit and tie on, which tells me, and he's in a well lit place, so I think he's probably okay.
Counselor, can you hear me at all?
Good Lord. And see, Sam,
Mm-hmm.
Share with us if we have some.
I think there's more background stuff going on there.
Just hang on. Just have him hold on your end. See
I can hear the judge.
if this is operational.
They turned the judge down really low now, though.
Counselor, can you hear me?
Yes, I can.
Good Lord.
If you're able to start over and pick up, or rather than pick up where you left off, start over on the issue of, we were discussing the depositions of the recently identified experts. We had confirmed that Dr. Harper's deposition was October the 1st. Dr. Berkland, my understanding, is no longer being called as an expert to testify, but is only being offered in some kind of advisory capacity. And all efforts to depose Dr. Brannon have not borne fruit yet. You can pick up where you left off.
Yes, we have tried to get that coordinated and have had no success with closing counsel. I am not even sure what this person can testify about. I don't know if it's another battered spouse as an expert. Florida law seems pretty clear that any other mental issues would have to be insanity. So I'm not sure exactly who this doctor is. We have prayed the court for relief and at least getting a report by today from him. We have not gotten such a report. So I don't know when we will be able to coordinate that deposition prior to the trial.
Okay. Mr. Owens.
Before he goes there, I want to say something else. Did you notice that Henderson and Beck are a no-show?
Yeah, I'm not clear why he added them even as co-counsel.
I think they're going to do what they can to help him, but I bet they're not. They know they're not getting paid, so they're not going to. I don't know. And then I also heard about the Berkland. They're taking out the doctor with the shady past. They're removing him from being a testifying witness to a consultant only.
So if that's the case, they don't have to turn a report over to the state.
That's how they're doing. Oh,
There's a rule, and I've been, if I'm wrong, I'm sure somebody in the comments will get it. If you're going to have an expert testify about your client specifically, then I believe the rule of evidence is that they then have to they have to turn over a report to the state.
but if he's going to be a consultant, he can't. So they can't use anything he says. They can only speculate what he's saying. Use that as speculation.
Yeah, if he's a consultant, not a testifying witness, then what happens is the defense just doesn't have to turn over any work product to the state.
Yeah, but at the same time, how does he come into play as far as the jury knows?
I don't know. I'm thinking on that.
Oh, okay. I feel like he's going to give them ideas maybe of what could have happened that evening.
I don't know.
And then they're going to talk about these ideas in their opening and closing statements, possibly.
That's possible. Is this the doctor that is the death investigator?
Yes. Mr.
So this is not the psychiatric doctor?
No, this is not the psychiatric.
Oh, okay. Then the rule applies to the psychiatric doctor. I don't know that they would necessarily. The testimony of how people died was really, really big in the Alec Murdaugh trial. And I think here, yeah, okay, so this guy would have testified to how he believed George died in the suitcase, right?
Like maybe he would have been going against the ME's report, debunking maybe some things that the ME would have said probably occurred or had, the injuries that they think that Sarah, allegedly, whatever. He would be debunking all of that it was Sarah that did it, right? That was the way we figured it.
Yeah, exactly. I mean, I don't know that And it could be, this is speculation. Everything I'm saying actually is speculation. But it could be that the doctor said, I will not testify to that.
Oh, you mean he had ethics?
It's possible that he had
Hmm.
some ethics. I'm not real sure about that, though.
You do realize this is the gentleman who stored body parts in Bob's U-Haul storage.
I do, but maybe he's learned his lesson and decided
Okay.
to be an upstanding citizen and model of,
Or could it be that just like at the ME's office that he was both two different counties that he was dismissed from, where he was supposed to be getting things done and he wasn't getting things done, and he wasn't getting things done for Sarah's case, so they've said we can't use you as a testimony. I think that they got smart and realized his background. Surely he knows of his
He's-
background
yeah,
already.
he's extremely impeachable, and it doesn't take a genius to see how that could backfire greatly.
Yeah, I mean,
So, yeah,
what?
I think that was probably a smarter choice to add him as a consultant and not as a testifying witness.
All right, let's move on.
Carrying on.
With regard to Dr. Birkeland, is Mr. J's position that person is not going to be called at trial accurate?
That's correct.
Okay, all right. So is there any reason to worry about deposing that person at this time, Mr. J? Okay. With regard to Dr. Brannon, are you still going to be offering him as a witness at trial, Mr. Owens?
Yes, Judge, and I'm going to be down there Monday night, and I'll be available all next week. I can do it at any time. The only two things I've got is the Dr. Holmes deposition on October 1 and the state's expert evaluating the defendant Sarah Boone on Wednesday, October 2nd. But I'm free anytime, and we can make Dr. Brannon available any day that week. I would assume we just have to get with him.
Mr. J?
It would be helpful if I had a report so that I could craft a preparation for this person's deposition.
What is the basis to require the production of a report?
Under 220F, you at your discretion order it to long so that I do not have to engage in a fishing expedition for an inordinate amount of time on the eve of the trial that is set to occur on October 7th, when I am unavailable on Friday next week due to an insanity placement hearing in Osceola County that has been previously scheduled and rescheduled numerous times. I am not opposed to working on Thursday, but Thursday is a court holiday, so we have arrangements. And Wednesday,
There are other persons in the media who are appearing virtually to observe this proceeding. I need you to mute yourself, please. There's an individual by the name of Blue. Sir, I need you to mute yourself in order for the court to conduct its business. Whoever is participating in the hearing this afternoon, whose name is Blue, if you can hear me, this is Judge Brannon. I need you to mute yourself, please. Mr. Owens, how are we going to be able to coordinate this step? Well, let me go back to you, Mr. J. 3.220F says, on showing materiality, the court may require such other discovery to the parties as justice may require. Is that your position that that allows you to provide the written reports?
yes, the court's discretion. Your expert was not produced a written report, nor have I gotten his CV to produce a report in efforts to coordinate discovery.
Mr. Owens, what response?
Judge, my response is it's a narrow issue, battered spouse. Dr. Brannon is an expert. I've mentioned him 2 or 3 times. He testified in the Marshall Thompson case in Palm Beach County. That's his field of expertise. It's not going to be a fishing expedition in his deposition. It's going to be related to that assault issue about its spouse. And I'm available Thursday. I realize that's a holiday, but I'm available as well. I can make him available. I'll do everything I can to set the deposition as soon as possible.
Okay, I'm going to pause it right there, and I'm going to recognize the elephant in the room, which you really can't even tell from this courtroom feed, honestly.
Not
You could-
yet.
Okay. The elephant in the room is that apparently we've done some investigating on our side. You know, Florida Sam is a private investigator. No, we've done some investigating on our side, and we've discovered that there's no possible way that would have been us logged into the Zoom stream at the time, because at the time I was still fumbling around trying to figure out how to get into or find the link. So whoever this was in the background was streaming, listening to us, I guess, while also logging into the Zoom meeting. Now, we by no means are saying they were doing it intentionally or anything like that, but that was what was happening. It was our voices that were out there. And I just wanted to address that it wasn't, we weren't trying
Cause,
to what?
cause mayhem.
Yeah. Because I mean, it after looking at everything and all the facts of it all, I would say that it shook me up pretty bad after I realized what was going on. At first, while we were on the live stream, I couldn't comprehend what was happening.
Right.
Now I do. Now I do, and I have posted something on my website apologizing. I would never want to ever interfere with the justice that this family deserves for the loss of their son, George Torres Jr., and their brother. And I also would never want to interfere with the justice system altogether, and allowing anything that we YouTubers, it always irritates me so badly when anything a YouTuber does affects things, because I feel like down the road it's going to hurt us. They're going to take away our rights with certain things. Because if you think about it, YouTube is still kind of, as the rules go, we're kind of still in trial mode, is the way I think of it. And at any day they could say no longer can you guys stream trials or do something like that, because it's affecting the courts and stuff like that. So I just wanted to make sure you guys understood that. I worked really hard on my channel to build it up. It's taken me a lot longer than I would have wanted to build it to where it is. It's not a huge channel, but to build it where it is, it has taken a lot of my effort. I do work full time doing this, and I would never jeopardize that. So that's all I wanted to say. Just get that out there. And Bruiser's upset too, if you can hear him in the background. All right. So I guess I'll move forward.
Yep.
Do we know if Dr. Brandon's availability?
I can try to get you on the phone now, Judge, if you'd like me to.
Any objection to doing that?
Dr. Brandon's on the phone. We have a deposition.
Mr. Owen, if we're in here, there's no need for anybody else to be on the line except
I can't control that. The media reached out to court admin today and said they were going to appear virtually. I'm trying to log into my app to silence this other stuff. I'm having difficulty.
Okay, so I don't know if you can hear what the judge is saying right now, but he's trying to explain what is going on with the Zoom, that on his end, he's trying to mute them, and that he believes it's a member of the media that is on the Zoom call, where you actually hear you and I in the background. And the judge is quiet. We can barely hear him. That's from the court TV feed. I think they did that in an effort to not blow out everyone's eardrums with the court Zoom, because it does. So if you're listening to this or watching this and you can't hear the judge, he's just trying to fix the audio. And I believe Sarah is turning red because she's mad.
If you can't see this here, but we went back and looked at Trial TV Live and their feed in it earlier today after the hearing had happened. And you can see, Prosecutor Jay, he is getting so pissed. He is so fed up with all of this. I think he's fed up with the whole media shenanigans and everything that's going on around this trial, but he is not happy about this. But I'm looking at little Sarah's face, and she seems a little amused by it all. Like she's liking it. I want to play her face again.
I don't know that she's liking it. I think she's I think she's feeling embarrassed.
Okay,
because her lawyer looks bad because he's the one that is having trouble connecting, right? He can't hear on his end for the first however many minutes this has been. And then the judge can't hear him, or he's screaming. It's just a mess.
I was wondering who she looked over at and smiled at. I'm thinking it had to have been Billy Lane's in the courtroom, I'm assuming. That's the only other person on her side of the trial that it would be in the courtroom right now.
Yeah, I don't know if, well, yeah, right, because any of the lawyers' staff, you're right.
there.
I don't know who else would be there. Or maybe she's got a friend. I don't know.
Oh,
Maybe she's got
a friend. Aw.
Yeah, wouldn't that be cool?
She got a friend. Okay. Hang
She's
on.
got a friend.
I just want to watch her face again.
Okay. So you can barely hear the judge. He's trying to explain, though, that there's a problem with the audio and somebody's open on Zoom. Now he's asking what the state's position is about deposing the death investigator.
Mr. Owens, are you requesting a different location other than South Florida versus the location of Dr. Brandon?
Well, we'll ask Dr. Brandon, but if he's willing to come up here to the deposition, I'm fine with that. We can travel. I'm available, like I said, all week next week. I'll be there whatever is necessary to get the case resolved.
Watch her smile here. It just, something not right here.
Mr. Owens, how are we going to be able to coordinate this step? Well, let me hear from you. Let me go back to you, Mr. J. 3.220 says...
.220F.
Yeah, I believe that what the state or what the judge is saying is he's trying to coordinate a deposition between the state and Mr. Owens with one of Sarah's experts. It's Brannon, I think. And what the state has just said is going to say, because I don't know where we are exactly.
I know, sorry.
That's okay. The state is going to say, once again, that Mr. Owens is not following the rules as to location. And so the judge is trying to hammer that out between the two.
Okay.
Showing materiality, the court may require such other discovery to the parties as justice may require. Is that your position that allows me to provide written reports?
Nor have I gotten the CP to produce a report efforts to coordinate discovery.
Mr. Owens, what's your response?
Judge, my response is it's a narrow issue, battered spouse. Dr. Brandon is an expert. You know, I've mentioned him 2 or 3 times. He testified in the Marsha Thompson case in Palm Beach County. That's his field of expertise. It's not going to be a fishing expedition in his deposition. It's going to be related to that assault issue, battered spouse. And I'm available Thursday. I realize that's a holiday, but I'm available as well. I can make him available. I'll do everything I can to set the deposition as soon as possible.
Do we know Dr. Brandon's availability?
I can try to get him on the phone now, Judge, if you'd like me to.
Any objection to doing that?
Dr. Brandon's on the portion of the deposition.
Mr. Owens, we're in here. There's no need for anybody else to be on the line.
I can't control that. The media reached out to court admin today and said they were here. I'm trying to log into my app to silence this other guy. I'm with you on the difficulties here. And I sympathize with it, but I don't have the ability to be an in-person deposition no later than Thursday of next week, the 3rd. If you are unable to have that deposition coordinated, you need to let my office know immediately. We will set a hearing as necessary. I need trial next week, but I will make the time in order to make that happen.
They are working as listed on the witness list in South Florida. So under the rules, the deposition should happen there, unless Mr. Owens is requesting a different location.
Mr. Owens, are you requesting a different location other than South Florida versus the location of Dr. Brandon?
Well, we'll ask Dr. Brandon, but if he's willing to come up here to the deposition, I'm fine with that, and we can travel.
The audio tech, they need they need a IT guy in there in the damn courtroom. I mean, come on.
Yeah, it's really bad.
All right, so I'm going to continue to play all the way through, and then we'll
Okay.
make notes.
I'm
Okay.
trying to make notes from what I can hear.
I know, right? We'll figure it out.
In-person deposition, the issue is simply location, whether it's in South Florida where his office is or here.
Doesn't matter to me.
Okay? Then you've got your deadline by next week, Thursday, to take that deposition. I have reviewed these responses to multiple matters, including the amended exhibit list and the second amended exhibit list, a response that the state had filed regarding a second motion. Was there a second motion to suppress that was filed?
Yeah.
Late last night, contained within that objection to the state's evidence was basically an unfiled, completely insufficient motion to suppress statements based on a statement made to a patrol deputy prior to the first statement to detectives in an unmarked patrol car on February 24th, 2020.
I have not seen when that hasn't cleared the court file yet, I don't believe.
Judge, I believe I sent it directly to the JN. Defendant's objections to plaintiff's exhibit list. Would have been sent to Ms. Darius.
I have
Last night.
Mr. Owens, the second paragraph of the second page of the objections seemingly refers to a different interrogation than what is made reference to in your motion to suppress of September 24th.
That's correct.
Okay?
May I be heard?
You filed your objections. As of right now, there's only one pending motion to suppress. Is there another motion to suppress that's going to be filed?
I'm not sure, Judge. I had some time constraints on filing this defendant's objections to plaintiff's exhibit list. I put those last two paragraphs in page 2 on there for the purpose of preserving that issue because my client asked me to. Whether or not I'm going to file those or not is an issue that will be decided on Monday when I drive down to speak with her. I may or may not file those, but I wanted to preserve that potential issue object.
Any further response to that, Mr. J?
He's not responding, he's just
No audio. You can't even hear the state's response.
No, I can't hear. I can't hear anything.
They cut the feed, the audio feed.
There's really nothing. Like if you turn it up.
Cannot hear you, sir.
No, I've turned it up as far as I can.
Can you hear me now?
Yes, sir, we can.
I'm sorry. That was my error.
What if any response do you have to? My concern is I don't have a complete picture of what is attempting to be filed, and you're telling me you're not going to be able to know until you meet with your client on Monday as to whether or not you're going to file a motion to suppress. We're rapidly proceeding to trial in this matter.
I understand that, Judge. I had a deadline for filing these defendant's objections to plaintiff's exhibit list. Based on my last discussions with Ms. Boone, she expressed concern about those two statements on the second page, the last two paragraphs. I simply was preserving the right to make an objection on the two exhibits, which is the body camera of Bethany Rodriguez and the audio tape that was taken, the interrogation that was taken in the squad car by the two homicide detectives. I don't know whether I'm going to even file a motion to suppress on those two paragraphs on the second page. I plan on driving down Monday. I will see her Monday night. We'll make a decision at that time. But I felt like I had to preserve that issue and this objection of these exhibits.
The clerk is going to call you right now. I apologize, Jay.
Now maybe the audio will go back to normal.
I don't know. Oh, there she smiled at someone.
See, she's smiling about. I'm like, what the hell is she?
Not about this mess. I feel like she feels like her lawyers don't look good.
Mr. Owens, can you hear us?
Yes, I can.
All right, very good.
Oh, thank God. Okay.
State what, if anything else, with regard to the objections as raised, making reference to another potential motion to suppress.
Judge, the state's entitled to pretrial rulings on all of these issues involving constitutional rights being violated. If the court gives the state an adverse ruling, we need the ability to file a petition for a writ of certiorari because we do believe these statements are crucial to the case. And as I outlined in one of my responses that I filed today, there is a uniform pretrial order that was issued in this case, as in every case, which clearly spells out to the defendant that she has to file all of her pretrial motions 10 days before a pretrial conference and get them heard. And here we are at the time of the pretrial conference, and we're still kicking this can down the road as to whether or not we kind of maybe sort of might file a motion to suppress. And so we're just asking for them to file it. And if they're not, then perhaps we will do something so that we can get a pretrial ruling on the constitutional admissibility of these statements so that there's not an adverse ruling during trial, which the state can seek no relief from. I don't think we're asking for much. It's been over 4 years. She's been well aware of her statements. She's gone through numerous counsel. It's not unfair to ask the court to get an answer. Are we going to do this? Because if so, when are we doing this? We can't do it next Friday. We We can't do it next Thursday, as far as I know, unless we can get Judge Munyon to open up a courtroom. And then we will have to deal with, are we in South Florida? Are we doing a deposition of this late expert? What part of the day? And then Wednesday, we already have the bulk of our middle of the day consumed by going out to the jail, which will probably take from about 10 a.m. till 3 p.m., going from travel from here, getting through the screening process at the visitor's entrance, and getting back to the female dorm, and then reversing that process. And then we have the deposition of their expert on Tuesday. So we're kind of running out of time to do these things and to coordinate and make sure that the two detectives and now potentially this patrol deputy have availability when they were never asked to be made available next week. They've been asked to be made available for the 3-week trial period. So I don't think we're asking for much to just get an answer. Are we going to do this motion to suppress? And if so, when? We already have a motion to suppress issue to deal with the 2-hour and 6-minute interrogation, which is going to take probably about 4 hours between testimony from the witnesses, the court watching the full 2-hour and 6-minute interrogation, and then arguments of counsel.
Anything further, Mr. Owens?
Before he speaks, do you want to weigh in on that? Because I totally picked up what's going on, and so I started off since we missed the first part of it. So they filed a second motion to suppress her interrogation, but in this particular motion that they filed, they did I want to just say it, a half-assed job at adding in the Deputy Rodriguez, the body cam of the first officer on scene of what Sarah was saying to her, and then also the squad car audio. And he said, well, James Owen says, well, Judge, we've had a time restraint and I couldn't get those filed properly, but we're preserving our rights that if we need to come back and file those motions later, we'll let you know, but we're not going to make a decision till Monday night until after we speak with Sarah Boone. So with that being said, I'm going to let Sam respond to that as to what the state's saying.
State is saying no, no, and no. Like, what are you doing? Why are you doing it? Like, is this happening? Is this not happening? He doesn't like the way that Owens is flip-flopping on things. He wants solid answers, and he's saying that he's entitled to them under the rules of criminal or civil procedure, which is that he gets them 10 days before a hearing. And he's, fed up, basically, that we're looking at trial with stuff still outstanding. And as of today, Owen's still saying, well, I'm not sure about that, Judge. I'm not sure about that. So, and then he raised, then he got into, well, if this is going to happen, then we might have to put in for a writ of certiorari. And that means that you're stopping the trial for an appeal, basically. So he's mad. I don't blame him.
I don't blame him either. I mean, dang. They've been sitting around over at the state's attorney's office waiting for a really long time to prosecute this thing. I guess I noticed her though, like when she was listening to what he was saying, she started that heavy breathing thing, and then she got that little look on her face, like she was like it's a smile, but I think it's an angry smile. Did you watch? Were you watching her breathing at all?
Mm-mm.
It was like her breathing intensified, as if she was like, when you get angry.
Yeah.
I don't know. I mean, that could be reading into that, but I noticed that, and I also the thing about him trying to come back and keep pushing and pushing on this, just the weasel Owens is trying to keep doing this, and then at one point is it going to turn into we're a day away from trial, and he said, well, Judge, this is why I told you, Judge, I needed a continuation. And
I mean, he's not going to get one.
No, I don't think so either, but I think that's what the state's going, that's where he's going with this.
Well, here's ultimately, if you think about this using some common sense, of which I have a little, Owens met with Sarah several weeks before he ever filed a notice of appearance.
Yep.
So that would say to me that if with her before I just can't remember how far back, but I remember thinking, okay, he saw her all those times before he ever filed a notice. He did well what he was getting into.
He watched all those interrogation videos and everything before this time.
He met with Sarah several times before he ever filed a notice of appearance. He knew well and good what he was getting himself into. He could have filed a notice of appearance earlier. You said, well, he had to have watched the interrogation tapes, and one would think so. Yeah, I mean, they've been on YouTube forever. But if he's going by what Sarah says, like Sarah says, there's this information in the phone, and Sarah says, they didn't remember. If he just is taking her at her word, which he should not be doing, that could be coming back to bite him. And if it's possible that he did not understand how serious Judge Cranick was, and he thought he could come down here and into Orlando and do his whole Pensacola shtick, whatever that is, no shade to Pensacola, and it didn't work, right? Because some of these lawyers are really used to just being like, oh yeah, blah blah blah, and then they get to do whatever they want ultimately, and he's not had to play by these kind of rules before.
He's not a member of the good old network. He don't believe in that. Judge Cranick does not. I love that.
No, he's not.
Okay. You ready?
Mm-hmm.
Dealing with my motion to suppress statements, I don't think it's going to be necessary for you to watch the 2-hour and 6-minute interrogation on that issue about whether or not the court should raise my motion. Again, on the issue of the pleading that I filed regarding my objections to the exhibits, it's the same response I gave before. I essentially felt like I needed to file them. I don't know whether or not I'm going to file any motions to suppress on on the Deputy Rodriguez's body cam. I'll know Monday night. I don't know if I'm going to file a motion to suppress on the interrogation in the squad car. I'll know Monday night. I was simply preserving that issue that we wanted to object based on that.
He's saying the same thing he said before. Exact same thing he said before.
That he doesn't know, and he'll know on Monday night.
Yeah.
And the state's going to come back and say, look, this is ridiculous.
But he does this every time, though, Owens. He doesn't argue. The state comes back with an argument. He doesn't know how to debate, I guess, is what. Like, the state comes back with an argument. Owens is supposed to come back with something a little bit more in addition to what he's already had there.
He needs to have substantive. I can't say it right now. Substantive.
It's been a long day, guys.
I can see the word in my head. I can't make it come out of my mouth. He's not actually putting legal argument into anything. He is just giving excuses and dates and names. Whereas the state is like, under this rule, under this rule, under this rule. And the state is absolutely 100% correct. And Owens is not correct. Although we were looking at one motion earlier today, or one filing earlier today, that it looked like he actually brought, it was the makeup one. There's actually case law in there, not for the makeup, but for some of the other stuff.
Yeah, which we're going to have to go over that in a separate video.
We're working as diligently as we can. I understand that Ms. Boone has had the case for 4.5 years, but I have not had it for 4.5 years, and I'm doing the very best I can to comply with the court's order to be ready for trial October 7th and still protect my client's rights as I see fit.
You're going to have till today to file that motion. You can buttress it, you can amend it, you can provide case law. The only thing I'm going to ask is that you provide the court and state attorney's office any case law that you plan on relying on. But you can always withdraw it if you need to after your consultation with Ms. Boone.
All right, would you clarify that again, Judge? So I've got until the end of business today, or the end of the day?
Any responses to that, Mr. J?
It makes no difference to my weekend at this point, Judge.
Okay. You'll have till the end of the day, sir, no later than 11:59 tonight to file that motion if you're going to file it, because the state needs to be advised as to what, if any, positions you have with regard to those matters.
And you're referring to a motion to suppress the statements made during the body cam of Deputy Rodriguez, and then a separate motion to suppress any statements made on the audio tape of the interrogation by the two homicide detectives in the squad car. Am I correct?
I am referring to the paragraphs that are in your objections. Second page, first paragraph, and second paragraph.
Yes, sir. I understand.
And make sure you got a certificate of service on it.
Did he say that?
No, I was just thinking that though. I'm like, I got to throw in a mic drop after he said that. Well, then you have to the end of the day tonight. Boom. I was like, oh, yes. Get him, Judge.
Yeah, so that's interesting. And it's interesting also that Owens does not know exactly what the judge is saying he has to do, like what of his filings, which says to me, I'm hearing about filings that I'm not recognizing. And I stopped checking the docket a long time ago. So there's probably stuff in there that I haven't seen. And I know I haven't read all of what was in there earlier.
Yeah, we still got to look at those. We'll have to do that another time. All right. Well, let's keep going. You could tell the judge is getting frustrated with him too. I think it would be hard to frustrate Kranick. He's just so even keel and so easygoing.
I think Sarah has probably frustrated him. I mean, he's had to come in and lay down the law, no pun intended. You know what I mean?
Yeah.
So I don't know. I think he's frustrated with it. I think he's exhibiting patience, but I think he's frustrated.
He's yeah, definitely. He's done a really good job with this trial, with this case.
If those are filed and when those are filed, I need you to favor copies to my office, please.
Yes, sir.
Now, regarding the motion to suppress that was filed on September 24, I understand next week's very busy. I know that my office had inquired if anyone was available Friday. I now understand the specifics as to why Mr. J is unavailable on Friday. As the parties are aware, the court, this is not the court's only case. The court is in trial next week. We have a legal holiday on Thursday. I don't believe that Judge Munyon has the ability to open up the courthouse just for me, as this is a statewide court holiday. That would be required of the Chief Judge of the Florida Supreme Court, I think, to make that decision. And I don't know that I have the ability to call Chief Judge Muniz to get that decision by Thursday to allow us to conduct work on that time. I will make myself available next week, but the problem is the scheduling of it because the court is in trial, and the state certainly deserves an opportunity to understand the court's ruling prior to trial in order to prepare what, if any, rulings would be adverse or for the benefit of the defense or for the state. I don't know because I haven't had the hearing. With regard to the 4 hours, Mr. J, why could I not review that 2-hour and 6-minute interrogation prior to the hearing such that we would be able to save some level of judicial efficiency and economy?
I have no objection to the court doing that. I just understand that some judges in this building do not do that.
I don't have a problem looking at it in advance, and that way if there are certain things that either yourself or Mr. Howens wants to highlight for me during the hearing, look at time step X or Y, certainly I'll give you both the opportunity to do that. But I think for judicial efficiency and economy, I don't have a problem reviewing it so that we don't have 4 hours of hearing time. Maybe we limit it at 2 for the purposes of case law argument and any testimony.
Judge, if I may.
Yes, sir.
If I may. Friday, I know there's 2 prosecutors on this case. I understand that this prosecutor is going to be elsewhere, but the main prosecutor who's prosecuting this case that would be available Friday for a hearing on this issue about my motion to suppress.
I'm handling the motion to suppress issue.
Okay, that answers that question. Mr. J is handling it. So
Jeez.
I am here at your disposal, gentlemen, for when we might be able to set this motion for hearing.
Judge, if I may, we've been in contact with Dr. Brannon, and he is available on October the 3rd at 3 p.m. waiting on a location from him, but I believe which that's Thursday at 3 p.m. That's the holiday. So I'm available that day. We just got to check with Dr. Boone about which location, whether Orlando or South Florida, where his office is.
The state's not willing to go to South Florida for a 3 p.m. dep on Thursday night. We'll be ready back in town and get a good night's sleep before doing the He's not willing.
Mr. Owens, hang on, please.
He's not willing to do it up here, then we'll need to coordinate another time during the week.
Okay. 3 p.m. is not going to work based on the state's schedule and what they have to take care of on Friday.
Okay, I'll try to get him up here for that date and time, October the 3rd at 3 p.m.
Are you stipulating? Are you stipulating then, Mr. Owens, to having Mr. Brandon appear in person for the October 3rd at 3 p.m. deposition here in Orlando?
I can't stipulate without talking to the doctor first, but I'm going to make every attempt to get him up here. But I'll let the court know, hopefully this afternoon, and the state know this afternoon.
Okay. All right. Getting back to the September 24th motion to suppress. State, how can we tee this thing up for hearing in time, understanding that you're out of pocket on the 4th?
Judge, I'm available Monday. It's my understanding that opposing counsel will be in transit to the Orlando area on Monday, so I don't know of his availability. On Tuesday, we are taking the deposition of Dr. Harper from 10 a.m. until I'm concluded with that deposition, but we should have afternoon time, especially if it's only going to be 2 hours on Tuesday the 1st. And on Wednesday, I can make myself available to do it at 8:30 in the morning with the court prior to us getting ready and going out to the evaluation at the jail, or we could do it afterwards at 3 p.m. on Wednesday when we are done at the jail.
But 3 p.m. is when the evaluation concludes, correct?
She says 2 hours, but what I'm trying to include into that is leaving the female dorm, getting back to our cars, driving up I-4, getting to the courthouse.
Okay, so that's a 3 p.m. ETA here.
Yes, sir.
Okay, got it.
Judge, my only concern is I know the two homicide detectives, I anticipate the state being able to have them available whatever day, but I do want the custodian of the records to bring from the sheriff's department, so I have to subpoena them to bring the policy and procedures and the Miranda card and the waiver of rights for them under the Miranda.
Any response to that? Okay, all right. We'll make it happen on Wednesday. I'll advise the ASA and the defense in the trial that's set for Monday that we're going to have a hard break at 3 o'clock on Wednesday. If we have to work a little bit after 5 o'clock, I will let my court staff know that we may have to work a little bit later that evening in order to make that hearing happen. State, are you going to be able to subpoena your witnesses in time to get them here?
They will come.
All right. Defense is Wednesday at 3 p.m. acceptable. Mr. Owens?
Yeah, I'm here, Judge. I'm sorry.
Wednesday, October 2 at 3 p.m. for a hearing on the motion to suppress.
Judge, I'll work on getting my subpoena out today for the motion to suppress Wednesday, October the 2nd at 3 p.m. Eastern Standard Time.
Correct. At that point in time, we'll also address the motion that was filed at 1:13 this afternoon regarding clothing, etc. For Ms. Boone. I conferred again this morning, Mr. Owens, with Barry Click, Public Defender's Office. She has not heard from you yet. Are you going to be relying on the Public Defender's Office to provide clothing? They are still ready, willing, and able to do so.
No, Judge, we were going to provide clothing for Ms. Boone.
Okay.
We wanted to get out there one day, early, Tuesday probably, to take measurements from her.
That's something you're going to have to address with the jail.
Okay.
I know I saw your motion. I don't even know if the state's had the opportunity to review it yet.
I have. I believe the shackles portion of the motion has finished it with appearance failed, and I believe all the clothing issues have been addressed by the court. The only thing we knew was the hair and makeup, and I did not see any authority cited that specifically said that was permissible. We don't really have a dog in the fight. If court admin and security staff, however it works, is going to permit this. Perhaps, as far as I know, the first person to ever have that done in this courthouse, that's between them.
Okay. All right. So the court will review that motion and the case law that you provided for me, and I will make a ruling on that in chambers as soon as practical. State, is there any other housekeeping matters or anything else from a scheduling perspective we need to address today?
There just appears to be a lot of discovery that is still outstanding, and that discovery includes medical records, different locations, and things, those specifically, and perhaps other things that are probably pertinent to all three of the experts, the two defense and the state's expert on battered spouse syndrome. So I don't know how we want to handle that, because if this information finally does come in, and again, I believe the court has already accepted the state's arguments that once jeopardy has attached, then it's too late. But there comes a point in time where it's too late for us to get this new information to all three experts and then redepose them as well. So there is my concern with this outstanding discovery, just as it relates to the experts.
Okay. Mr. Owens, any response to that?
Judge, we'll call today to see where, if the medical records are en route. We'll get the state an answer today, one way or the other.
Okay. Get the state an answer today, one way or the other. But if it's Friday next week and you get them, that could be problematic as to whether or not they're going to be permitted or not. I'm not saying yes. I'm not saying no. It's just the closer we get to trial, the limited opportunities we have for everybody to understand what those records are.
Judge Clay, we're doing the best we can.
I understand that. Anything else from a scheduling perspective, state? Mr. Owens, anything from a scheduling perspective from your side of the ledger?
I don't believe so.
Okay, all right. Are there any other matters with regard to trial that we need to address starting on October 7? Jury selection is going to be here in 12 Alpha. I outlined previously the amount of people in working with jury services that I'm going to be bringing in. The court's druthers are in the morning to have 50 people, address any preconceived notions or knowledge about the case, and cause challenges as to our jury sacrificing 3 weeks out of their life to come participate in this process. And for those that may be able to do that, I will give them a number, or Madam Clerk will give them a number for jury services to call for when they're supposed to return. I then intend on having another panel of 50 at 1:30 that afternoon. That will continue until we have a panel of 40 to 50 persons for which to select our jury from. Does the state have any questions with regard to that process?
No, Your Honor.
Mr. Owens, do you have any questions with regard to that process?
Judge, are we going to be in a bigger courtroom than the one you're in now?
No, sir, but we can fit 50 people in here. In the gallery, I can fit 50 prospective jurors. And I've already coordinated with the sheriff's office to ensure that we'll have the appropriate number of seats in order to make that happen.
Okay.
So any questions with regard to that protocol?
No, sir.
Okay. All right. Anything else that we need to address, state, from your side of the ledger?
Just that based on the battered spouse syndrome evidence, we are, as well as the defense, working hard to get everything in rebuttal put together for that. I believe they have listed all the patrol deputies for the prior interactions that the defendant and the victim had in this case. We're going to be listing those as well. So I don't think that would constitute any surprise or great shock. But other than that, I think that's all the state has.
Okay. All right. anything else we need to address from your side of the ledger, Mr. Owens?
Just some discovery issues, Judge, but I think we need to deal directly with the state on those.
And discovery issues, what are you referring to specifically, just so that I'm clear?
Well, there's a public surveillance video from Publix that we cannot get to play. We received it from the state, but we requested new videos or a specific program, but it will not play for us. I assume that's the one either where Sarah Boone and George Torrez will go into Publix the first time, and there was a second time that just George Torrez went. So we're trying to get that. I think we're trying to get an updated address on Melissa Sexton, which is a witness that I think is listed by both the state and the defense. And then we have an address for a Deputy Zito that's a P.O. box. We probably need a better address from that. So just some stuff that the state and I can get together and try to resolve.
Okay. All right. Anything else, state? All right, Mr. Owens, anything else?
I don't believe so, Judge. We're going to do our best this week to get all this resolved and be ready for trial October 7th.
Okay. We will see you next week on the 2nd at 3 p.m. for hearing on the motion to suppress, filed September 24, and for trial on October the 7th. With that, court will be in recess. Thank you all very much.
Thank you, Judge. Bye-bye.
Okay, so you mentioned that Deputy Zito.
Mhm.
That is from a prior incident where we've seen some body cam footage from. So that's going to be interesting because they're going to bring up some of these other incidents where she had called the police on George. I don't even want to look at her. The first person ever to have their hair and makeup done by a professional in this courthouse, per Prosecutor Jay. I loved how he clapped back on that.
Yeah, he's standing firm, and I love it. And he's inserting enough snark to keep it entertaining. I didn't make it all the way through the long motion. I started reading it on the live stream, and then I guess we got whatever court feed we got, and I went away from that. So I'm eager to finish reading that and see what all he has to say about everything. I didn't realize that they're still arguing motions, the original motion filed on September 24th, which was like 3 days ago, right? But it feels like it was many weeks because of how fast this is moving.
Yeah. Wait. So those are his first motion was just to suppress the interrogation in the police. Well, it was the sheriff's office, and then the second one now he threw in the other two, which was with Deputy Rodriguez and her interview with this in the squad car. So let's see if he gets those in by 11:59 p.m. tonight.
I mean, look at this. So on the docket, if you look on it's 9/27/2024. It's a document entitled State's Response to Defendants' Objections to Plaintiffs. And so somebody made a mistake. They made a typo. The apostrophe is outside of the S. So the parentheses or the brackets with SIC in them means that whoever originally wrote it made the typo. And instead of just putting it, like fixing it for their filing, they're just copying over. And I've seen them do it on other things too. So whenever Owens's office makes a mistake, the state copies it in their response, and I think it's hilarious. You know what I'm saying? Like, does that make sense?
No, it does. Yeah. I love how he always uses that term, Judge, we have no dog in this fight. So they're actually gonna address the clothing and hair and makeup and all that, which is awesome. They're gonna do that on Wednesday at 3 p.m. So we'll be back for that, and everybody should be in the courtroom. So we should have a normal court hearing that day,
Right,
and
in person, so we don't have any of this insanity with the Zoom, right?
yeah.
And
I wanted to ask you something about
yeah,
this. So he said that there was a lot of first he said there's a lot of outstanding discoveries such as medical records and whatnot. And then he made a comment about jeopardy attached. Once jeopardy is attached, it's too late. What does that mean?
when a jury is sworn in, then jeopardy attaches,
Okay.
and you cannot. It's called double jeopardy if the state tries to bring the same case against you more than once. So, um,
I heard about that. There was a movie with Ashley Judd in it about that.
yeah, exactly. Yeah. So if you go through a trial and you're acquitted, the state can't turn around a few years later and charge you with the exact same murder
Right.
on the exact same charge. That can't happen. It escapes me at the moment.
Well, I was just thinking. So basically, what they're saying is, in regards to these outstanding discovery items, if you don't get them in before the jury's sworn in, we're not gonna. We really, there's no reason why the judge should allow them to come in
Yes.
after that.
There you go. Uh-huh.
Okay, that's what
That
I'm kind of
makes
going.
that
All right.
makes sense.
And then, of course, the judge laid it out again. We love how organized he is with this. He says, "Okay, first of all, first thing we learned was it's going to be in the same courtroom. So,
Mhm.
welcome to the audio from hell, everyone. This is what we're stuck with." And he's going to bring 50 people in the morning and 50 people in at 1:30 p.m. And hopefully, of those two sections, he'll get 40 to 50 people. If he doesn't get 40 to 50 people, he'll go on to the next day. He wants 40 to 50 people panel to select a 12 juror.
So it'll
Yeah.
probably be a 14 people will
Oh,
be
yeah.
selected because you're going to need at least 2 alternates, and if he's being really cautious, he might go up from there to 4. Um but yeah, I was a little surprised. Owen, you heard Owens ask, "Is this the courtroom? Are we going to a bigger courtroom?" And he says, "Nope, I can put 50 people in here in the gallery." So that tells me that people who are trying to go there and show up for that trial, uh, those seats could be taken very quickly.
And because Cranix, like, look, this is my little throne, and I'm not going to uproot my setting just to because I'm sure on their side, for admin side, court reporters, all
Oh
that,
yeah,
I'm sure it's a
100%.
big deal for them to pick up and move to another courtroom. So
Yeah.
I get why he's saying that. I mean, he can probably. He's not worried about the media. He's not worried about any of that. He's worried about the justice in this trial, and I love that about him. Although I
Mhm.
wish he would really do something about the audio. But there's
Well,
nothing you can do. It's not
it
gonna be as bad once they're in the courtroom.
didn't seem like it was too bad this last part, except for the Zoom part where Owens is talking.
Yeah.
That was bad, but the in courtroom sound was fine.
Yeah. Did you pick up on what he was saying about the Publix video? This Owens brought
Yeah.
this up when he was talking about, I guess, the witnesses and whatnot. He said that he said the two Publix videos, the first of Sarah and George and the second of George. So she went to
Well,
Publix with
he
him the
said
first
we
time.
think.
Yeah, I heard that somewhere else. Somebody else had said that they had seen that there was a video out there that George and Sarah were both in the first one. I don't know if anybody's actually seen the video, but there was talk of it. So, that must be true. I wasn't going to say anything until I knew for sure.
I don't know what's on it. I feel like there's conflicting stories about it. Um, but my guess is okay. Think about this. So the day George was murdered, they found the Publix receipts. So a detective or an officer would have immediately gone to Publix and asked for the surveillance camera from the night before. So it would have had to have been the day before because they wouldn't have thought to go back any further. And a lot of businesses don't keep it very long. So I guess we can rule out like old footage of Sarah and George slinging potatoes at each other and
Well,
just think
well,
about it in terms of them going in there that day.
I don't know how old that was, but I was thinking too, though. So the sheriff's office, they get those three receipts. They go to the Publix manager and they go, "These three receipts, these timestamps. I need to look at the video of these three receipts." So I'm thinking one of them was the day before. So we might actually see footage from the 23rd. I don't know for sure. There might be footage from the 23rd and also, I mean, the 22nd. Yeah, the 22nd and the 23rd. I don't know. I don't know what they have. I was kind of trying to play that out in my head. There was 3 receipts. 2 were from the day of the 23rd. He died that night or that early in the next morning. And then supposedly there was another bottle of wine that was already in there. And I'm thinking it was bought the day before, but I don't know that for sure.
Well, I
Because
guess
all
we'll
I know
be
is
finding out.
yeah, there's so much we're going to find out, guys, and be able to break down. And y'all know how anal I get about this. I want to break it all down and I want to understand it. Thank you so much for being here. And girl, you spent all day on stream with me practically. So I just want to thank you so much.
Well, thank you. It was fun and chaotic and fun.
Different. It was different.
A little stressful.
It's a little from time to time, but hey, the day ended up okay, I think. I think we're going to be okay.
Yeah,
All
absolutely.
right. All right. Well, bless your heart. We're doing the best we can, Judge. We're doing the best we can. All right. Thanks for joining us, everybody. We'll see y'all next time.
Bye.
Bye-bye.